There was no service on Kyle Robertson.
He's refusing to answer any
No,
questions.
it's the 15 one. Okay. The 12, no service on the 15th. Okay. Is Kyle Robertson here?
No.
Okay, Mr. Brunette, you're here on behalf of the matters of Mr. Smith.
Yes, Your Honor. Good morning.
Good morning. Looks like no one appeared today for Lathview versus Robertson, and this was a motion to show cause. Did you want a bench warrant to issue?
Yes, Your Honor. The balance today is $1,466.
50%.
50%. Okay. Okay, we will submit that to the court. I believe that's all I have. Thank you, Your Honor.
Thank you. Oaksville Properties versus Sandy Property Management. Like Chase Carlson and Amanda Williams, 24-07290. Council, can I have your appearance?
Good morning, Your Honor. Jessica Larson appearing on behalf of the plaintiff.
Is this Amanda Williams?
It is.
Okay, and Mr. Carson, you can remove your hat. This is the court proceeding. Okay. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand on
in written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
Sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom, and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm gonna make it clear on my record that I don't make, and I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let
I run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we speak?
Do you understand that? Yes, you may.
Well, we tried to tell her the funds, we can pay them. We have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor. I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtors exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially, but I've received the judgment is for you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Then I guess I misunderstood, and that goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We make a video, we make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language, you have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry, Your Honor.
I'm sorry.
I asked him if he had any of the documents there were, in addition to information, the documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her.
You instruct yourself. You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady. That might work with the lady sitting next to you, but you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date. September 4th at 1:30. September 4th at 1:30, you said? Yes, in person at the court. If you pays in full, you can provide evidence of that and have this removed from my docket. Any additional matters for the record?
No, Your Honor, thank you very much.
Save the tax and money.
Mute him and remove him from my courtroom before he's in contempt.
I wait for the notice.
Yes, thank you.
Thank you very much, Your Honor.
Okay, this is Valerie Lapka versus Jeffrey Beagle, 25-01722. Beagle here at all?
See, October 6th.
Councilman, have your appearance.
Good morning, Your Honor. Attorney Pamela Amato on behalf of Mallory Lapka, Scott and Sealand.
Today was the date that was set for motions to enter judgment. Okay, let's see if let's see what to do today. This is for default judgment. Didn't enter for some reason. Let's see if there's a note to it. It says the clerk's office left a note. There was no accounting or bill of costs provided for the request for attorney fee. Let's see. I think that's what the issue was. You have an accounting or a bill of costs for that.
Yes, Your Honor, that was attached to the complaint.
But the clerk's office put a note that they did not receive it.
Let's have a copy of the. What would like you to do?
Yes, please. Is this our copy or do you need a copy?
I can make another copy, Your Honor. The court can have that copy.
We can make a copy right here if you need it.
That would be.
Okay. Okay, your judgment will be signed and dated for today.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
No, Your Honor, thank you. Your Honor, I have a second copy if the court wants to retain the original. And doesn't do the copy.
Of this?
No, of the judgment that I handed to the court.
Oh, I think a default is in the system. Yep, I'm signing it in on base. Thank you. I can take that for it's been signed in on base.
Thank you.
Thank you. Thank you.
Thank you.
Thank you. This is Pacific Flats versus Joshua Johnson, 25-00686. Yes, please.
Written on 69542, application of the Pacific Flat, along with my property manager, Teresa Williams, will be approaching to my right.
Okay, let's see. Thank you. Okay, and today was the date that was scheduled. This is for a jury trial that we're moving forward without a jury for a eviction for non-payment of rent and believe a counterclaim. Is that correct?
That is correct, Your Honor. For the record, we do have possession of the unit, so we just moved, and it was not a money judgment, so we moved forward on Mr. Johnson's counterclaim. I do have one housekeeping matter, Your Honor. An order was issued by the court for plaintiff's motion for entry of judgment to be granted. I'm not sure if that was issued an error. I do have that for the court.
You said there was a motion for what?
Entry of judgment, and then the court granted it. So that was to enter judgment, dismiss the counter complaint back on May 15th of this year.
Your Honor, can I?
Yes.
One
Let me
thing.
just a moment, because I don't see where I signed it. You said something was signed when?
May 15th, Judge. If I can approach.
I see chronic claim, I see. Motion for April 29th. I see I signed an order for escrow, it looks like. On the 15th. There's nothing else in this file. I don't see that signed on the 15th. There's an answer on the 15th that was filed. I'm sorry, on the 2nd. Service from other differences. There's nothing in this file that reflects this. I don't know what this is.
Your Honor, with that, I will say something really fast.
Yes.
Okay. They are running scared right now. They asked you last week to drop my lawsuit 3 times, and then they didn't even allow me to even start, even though I'm a plaintiff in this case against them. They wouldn't let me start. I have a lot of, well, not a lot, but I have proof that shows that they have continuously lied about many other things, including the $1,400 that they stole from me. I can prove that their ledger.
Well, that's what we're here for today.
Correct.
I'm
That's
not,
wanted to say.
I'm not sure. You said this was through on base in response to what?
So plaintiff filed a motion for entry of judgment pursuant to the court rules, no tribal issue of fact. And that.
This was, let's see here. When did you file it?
Second. I believe that was on around April 11th, Judge.
April 11th was the date we had joint pretrial statement filed. I signed and dated a joint pretrial on April 11th. So there couldn't have, I don't understand what the motion would have been for. And it could not have been a motion for default because he was clearly here.
No, it wasn't for a default, Judge. It was for no tribal issue based on the counter complaint, but I will.
I don't see that motion in here. And then on the 14th, it looks like of April, I ordered you all to undergo case evaluation. Which the clerk's office reached out to me last week about because it had not been scheduled yet. And I almost canceled this because that was an order to undergo case eval.
Judge, I believe, I apologize, Your Honor. In response to your question earlier, we posted for entry that was filed April 1st. With regards to,
let me stop. I'm looking at my file for 25-00686. There is no filing on base on April 1st. We have a counter complaint that was filed on March 24th. Pretrial statement was the next thing in the file, April 11th. April 14th, my order for you all to undergo case evaluation. Your jury trial demand, the jury trial demand was on the 17th. Looks like there was, yeah, I don't have anything April 1st.
with regards to case evaluation, Your Honor, we did settle this at mediation before the case evaluation. So that's why I believe both parties were under the impression that the case evaluation
was not needed. Well, I think that I moved the trial day up because I think it was supposed to be scheduled. So I assumed that you all at the last hearing made it clear that you didn't believe that case eval was meaningful. And so that we just needed to move forward is with how we got here. That was why I told the clerk's office we would move forward with today's date. I don't know what this is. It's not in my file, so we can move on.
Thank you, Your Honor. I would like to start with my opening statement, Your Honor.
We'll let them have a seat, please.
Okay. Okay, Your Honor. I would like to start my opening statement by addressing the defendant here.
You address the court. You don't address the defendant.
Oh, I'm sorry. Okay. I would like to give the Webster's definition of the word fraud: deceit, deception, trick, artifice by which the right or interest of another is injured. A stratagem intended to obtain some undue advantage, an attempt to gain or obtaining of an advantage over another by imposition or immoral means, particularly deceptions in contracts, or bargain and sale either by stating falsehoods or suppressing the truth. Your Honor, please keep that in mind while I present my evidence. Let's start from the beginning.
All right, are you calling witnesses, sir?
No, I'm not. I just
raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Okay, you can give your testimony.
I would like to hand the court.
You don't hand the court a file folder, you present your evidence, and then if you have exhibits, you can request to admit the exhibit to support your testimony. They would need to have had a copy of the same exhibit or to review the ones that you have, okay?
Okay, okay. So this would be theirs and I use this one here. Okay. So starting from the beginning, let's see. I can never get a ledger from them, nor does the court have a copy of any ledger before November 2023. I was never able to get them to give me a copy of the ledger before that date.
So you do have one, but it's not before.
Correct. I have theirs and mine. Okay.
When did you move into this property, sir?
I moved into this property back in May of 2016.
Okay, so you've been living in May
Been there almost 10
2016.
years.
When do you, your allegations is for fraud, correct?
Yes,
And that you're alleging that they took some money that you had in your account that you pay your rent for? What is the name of this account?
it's just their rental account. I put extra money into it that I need to just for a rainy day for the day that I moved, or if they ever were like a late payment or something like that, it would always be there.
So you overpaid the account, is what you're saying? How much was your rent monthly?
My rent, it did actually vary and change, and I have the paperwork from LHC to support that as well
Okay.
too. So my
How much
portion
money
was
are you alleging they took out of there fraudulently?
$13.98.90.
13.98 and how many cents?
90 cents.
Okay, when?
And October 21st of 2024.
And how much was your rent October 2024?
October 2024, my rent at that time was. Our papers. Okay, there's gonna be January, November, October 1st, 2024 through May 31st, 2025. Now that changed in November too, but just for the month of October, I was paying $147.
Okay, for October, your rent, October 2024, that is, your rent was $147 per month.
For that first of the month, October, but November, it went to zero.
Okay, why was it 147 for in
Because
October?
I was working during that month.
Okay, and then in November you were not, and you were up to date at the time?
That's correct, yes.
Okay, and so when October, you pay your rent on the 1st?
Yes,
You paid, so October 1st, you put how much money in the account?
would have been $147.
Okay, and so your balance on the account was $147 at the time, or did you have?
No,
more money?
I had, it was, well, with the 1398 plus 147 would have came out to about, would that be 1550?
So you already had the 13. When did you put the
Yes, I already had
1398
it
in there?
okay.
When did you put that in there?
Oh, I put that in there long before they even owned.
I know, I'm
place.
asking the actual date. When did
Oh,
you?
the actual date that I had put in various amounts. So the last time that I had put an amount in was just before March 2023. Last time that I
Do
actually.
you have evidence of where you had this money in your account?
Okay. That's just. Okay. Here is. This will actually help support it as well too. Okay.
Josh, and maybe see that first.
Absolutely.
Oh, the same exact things I already sent you guys, but I have no problem doing that. So, make sure this is right. I just need a pen and write this down to make sure they know who's who's.
And just let her see it up here. Oh, counsel, you reviewed this?
Yes, Judge, thank you.
Okay, and so this is a ledger, is that what this is?
There are two ledgers. One is theirs, one is mine. Mine's the original, theirs is the alter.
I don't know what is which, because
Okay,
they all, you say altered, but they all have writing on it, which makes them altered.
okay. Mine has the 1398 for October 21st, 2024, right on the very front. Theirs goes into March of 2025.
Okay, I see March
Yep.
2025. I see something that says cap resident, I don't know what that is. And then I don't
Okay.
know what this is. Okay, so you're talking about this document here, sir?
That is my doc, that's my.
Okay,
ledger.
this says specific flats. As of November 6, 2024, it says there was a transfer from your bank. It says your balance was, well, you essentially had $800 in the account, correct?
I had 1398 in there just.
Well, I
before
said
the-
November 6.
By November 6th,
Okay.
they had taken everything and I had put 800 in there with LHC.
Okay.
LHC. put
I
in
see
800.
October 21st, 2024, rent charge $13.98,
Exactly.
wrong credit from MON account fixed by adding a rent charge. Okay,
Your Honor. can I ask
so
one?
let me
Yes.
just continue
Absolutely.
to understand this document
Most
here.
definitely.
Okay, so then rent charge $13.98, October 1st. So I see.
If you look at the months for the rent beyond or before.
Prior to that.
June, Before
Your
June
rent was $7.15?
was 715, yet their ledger says I was paying 800. And if you look, it was revised on January 15th, 2025, along with a lot of other.
What was
added charges.
revised?
That $800, adding it's an extra $85 to every month's rent, plus utility costs that I'm not required to pay, and I have proof of that. Including they never gave any written notice to LHC, which they are required to by contract to do. And I have email here. You have email as well from Candy from LHC stating that the only two things they sent though was rent change in June and in November. So how could I be being charged $800 back in November 2023 when you guys asked to raise the rent in June of 2023?
Okay, so you're saying
or
they charged you for rent that you believe you didn't owe and that they
That's
didn't
correct.
follow the protocol for your section 8
That's
to
right.
increase the rent.
You got it, exactly, Your Honor. And because of that, and they're putting me all through this hell, and they've tried 4 different attempts to take that money out of my account. 4th time is them just adding on these fraudulent charges.
And then you said they charged you for utilities. Where were you charged for utilities? It's
I was
not in your ledger. You're saying in
No,
their ledger?
In their ledger, they're charging me for utilities,
Okay.
late fees,
Water, sewer, trash.
correct?
And is that a part of your lease?
No, it is not.
Have you ever paid that?
No, I have not. Required by them to contact LHC if they want to make any changes to that. It's in the contract. They have a copy of the contract.
That's in their lease, you're saying?
No, that's in the contract between LHC and
Do you
them.
have a copy of
I
that?
sure do.
And who is Cammy Sutton?
Candy Sutton is LHC. She
Okay.
is my worker.
Okay, is that what this email is that you
That's
provided?
correct. That's
In
correct.
reviewing my email and your case file, I do not see any documentation showing an updated lease only a rent increase June 17, 2024, November 1st, 2024. When another rent increase was sent, documentation updating the owner information and was sent to Mr. on March 20, 2025.
I would object to this. Ms. Sutton isn't here to authenticate this. I don't, and for the record, Your Honor, this is the very first time I'm being presented with any of these documents. Very hard to form a defense when I don't know what the cause of action in which he's levying against my client. It was so broad, Judge, and I couldn't understand either counter complaints in order to, for lack of better words, give us fair warning as to what the issues are, that he is, he's asking for a remedy. The two remedies he's asking for are quite different. One's for around $8,000, one is for over 10. It's just, I know that Michigan is a notice pleading state, Your Honor, but he didn't comply with the court rules to give us an understanding of the case or the issues before us today. And this is literally the first time that I'm seeing his proof or his evidence, if you will, with no witnesses to corroborate.
Okay. I'm not really, this email about that it doesn't do anything for his case. He already testified to essentially what's in the email, and his testimony is sufficient for that. But I am concerned about the document you have there. What document is that?
I think it's the document that you just read off of.
That looks different than what I have.
Yeah, I don't know what you have, Judge. I asked him to give us the same.
Yeah,
It's the same
I
exact
will say you all
email.
forwarded over
It's
here. I
the
thought
same.
you saw it. I
It's the
don't know.
same exact email,
He gave
word
us
for word.
a copy,
Word for word.
Judge.
Okay, so yours has something on the back, because mine's just a truncated copy of it or something.
That's from computer sending emails. That's all that is. But it's the same exact statement, word for word
Okay.
from Cammy. The other one just had to be sent from my aunt.
Got it.
It was, I
Okay.
sent it to her.
No worries. I was asking though for, I thought maybe you had I don't really necessarily need this. I thought you were giving her a copy of the contract. That's what I asked for.
Oh, the contract, sure. Actually, first it was the utilities, right? To prove that.
No, I
pay
asked for
utilities.
I
Okay,
asked for
okay.
the contract.
Okay, then. Absolutely, absolutely. I'll use this one. So that way. This is for you, Your Honor,
Could you show it to her, please?
and that's for you. Believe me, Your Honor, I'm not the one that's got the false documents.
It's the time to give testimony, not argument.
I
Okay.
understand.
Okay, this is supposed to be the agreement for section 8, correct?
I'm not for sure what you're.
This is signed from March 1st, 2025.
Oh, 2025. Where's?
Okay, let's see here. It says here that you must pay the utility bill. So what do you mean?
I have here that states that the owners do.
What is that that you
This
have there?
is from my section 8 LAC. That's who this is from.
Show it to the plaintiff's counsel, please.
He is for tenant. I was
This
for
is
owner.
for request for tenancy approval. And this is from when you moved in.
That's right.
Okay, I see the April 22nd, 2016. Let's see. Got it. So you're saying T is for tenant, O is for owner. Says trash collection and water is paid for by the owner. Okay. Any other evidence you have to that?
Yes, I also
Because
have,
the basis of your claim is that they took the money out of your account.
correct,
Okay.
fraudulently, yes, and I have more proof here that shows they did that here. Show her exactly the months. I just want, Your Honor, before I do any more paperwork to them, I just like to make sure that I get my paperwork back from them.
I think I have it. Have you provided them copies?
Oh, yeah, I've been giving them copies left and right. Every time I've given you a copy, they've been
Just now.
taking one.
You mean
Not
today?
Just today and before. I mailed them a registered mail of the same exact things.
Did you
to them.
receive anything?
No, Judge.
If I went to the post office, I could get you a receipt of it.
Okay, well, you're presenting in court, you do have to give them a copy, and they said they never received any documents, so.
Okay, then here you go.
I'm confident whatever you're giving them, they don't want to keep it after today, I can promise you that.
Well, I can't say that for sure, Your Honor.
I can promise you that for sure. I don't want to keep it and they don't want to keep it either, we're gonna give you all your paperwork, you know how much paperwork we get? We
I
do not-
understand, but I don't
we-
want them retaliating against me.
They don't want, they
just
can't
don't want
retaliate
them
against you, you
retaliating.
don't live there anymore.
But by doing something deceptive that they've already done, as you'll see, they've already been deceptive.
Even if I believe that there was an error, I can't make
Okay,
a decision that it was because of intention to be deceptive, so.
Okay.
It could have been an error. I don't know yet
I
because I don't have all the facts. I don't know. Did it change
That makes
ownership or management or something?
With, no,
Well,
their
since you
apartment
moved,
complex,
the,
it's changed 3 times.
yeah, so
It's changed
errors
3 different
happen.
hands. Same exact copies as
yeah,
this.
you address the court, not her,
Your
okay?
Honor, the.
Because I don't want you to
copies are
become
exactly
argumentative.
Understandable. I completely understand that.
Okay, let's see. This is, okay, from November 15, 2024, notice of adjustment. And this is saying your total rent contract would be this amount, but your contribution was $12.
We'll be starting
And
from
then
the soonest
these are-
to the last, to the latest.
Okay, and then this one says, it also says your utility allowance payment is 0. This one says, what does that mean, utility allowance payment?
They will sometimes give you an allowance if the apartment do give them in writing an actual change, or they will give it to you for your electricity. as well,
Okay,
too. They'll give it
so,
for your electricity as
got
well.
it. So as of November 15, 2024, Mr. said 0.
Yes.
Got it.
And then there were a couple months they gave me like $2 or $3 for the electricity. And then it was stopped after only like 2 or 3 months. That's all it's for.
Got it. And then we have, it looks like now, January, or at least this was a January one, let me put this back in order. 2025, the allowance was $3. August 13, 2024, 0. This is January.
Careful of a June. There's a June 2016 and a
Well, I'm
June
putting them back in
2024.
order because it doesn't appear to be in order, but why is this both the same date? with
Some might
different
look
amounts?
a lot alike.
Why do you have a January 23rd, 2025? You got 2. One says your rent is $715, one says $800.
Or which month?
Both of them say January 23rd, Oh, that's when they probably noticed you. It says, this is the amounts are identified beginning September 24th to May 31st. And
Yes,
that
they'll
says
always
June
do to
20.
May 31st of the following year, but if they change it, then it will get changed before that.
Got it. So it looks like you got a notice. For whatever reason on the same, they sent this notice on January 25th, but it says June 1st, 2024 to March 31st, 2025. Your rent will be $7.15, rental allowance was gonna be, utility allowance is gonna be $3. However, it looks like they then adjusted it and sent you an update, September 1st, 2024 through May 31st, your rent was going up to $800.
Yes, as of September. It's going from 715 to 800 in September. But their ledger states all the way back to November 2023, I was supposed to pay 800. And they revised that, like I say, January 15th, 2025. Long after. Why would they ask me for the rent? Years after.
Okay, let's see here. I see.
Or take it, sorry, take it. Years
Okay,
after.
I see here your contract agreement says June 1st, 2017 to May 31st, 2018. Your rent was $5.15.
That was me.
Okay, and then it says your rent here from December 1st, 2022 until May 31st, 2023 was $7.15. And then it says February 22nd, 2023 to May 2023. $7.15. October 21st to May 31st. I see it's back to 800. However, these are not your contributions, though. It's
So-
saying what your contribution is, I believe here. It says your contribution 147 at the time.
Correct.
And so even though that's your total rent amount, the Section 8 is paying
The
majority of it.
653 on that month, but the other months, they are paying majority of it.
the
But I
majority.
had been paying,
It makes it clear, okay.
I've been paying extra into it throughout the years, just so that way I had a rainy day fund in October 21st for the third and fourth time. They just took it.
Okay, so if I look at your ledger.
Your Honor,
And I'm
they
trying to
made it confusing.
No, I'm just trying to see when, I'm looking at the one that you provided the court. It says at least March 1st. Your balance was, you had over $1,000 in your account. And then it looks like there was some violation charge. And they took $405 out.
A bed bug spray, Your Honor, they never even did. That was another part of my lawsuit. Along with $675 that they
It
originally stole.
says
They
violation.
didn't put in it.
Bed bug treatment, refusal.
They
That's
just
what it
never
says.
showed up.
It says refusal on day of appointment.
They just never showed up. I had argued with the redheaded lady about that one.
Who's the redheaded?
It was a woman long before this lady over here at the far end, was long before her. She, I think, might have trained underneath the redheaded lady. I'm not
You don't
100%
know
sure,
the
but the
lady's
redheaded
name.
lady,
So this,
I do not know.
so
that
you were home on March 2024,
March 20.
March 21st, 2024, and you're saying they never showed up?
Okay, that was the day that I found out they were stealing the 150 off of my rent. They were adding an extra 150 on my rent.
I'm asking about the bed bug treatment day,
The bed
Did you
bugs
let
that
them
they were
in
there.
or no?
I was there. Yes, I was there.
Did you let them in the property?
They never showed up.
Okay. Okay, so it looks like they charge you $405 for that,
That's correct.
and then
There is a
looks like, I see there's a 675.
Yes, that's the one. That was the 900 for a 6-month period at $150 extra a month. They charge me.
Rent was increased to $850 without proper notice to tenant or
Bam.
MSHDA. So they put $675 in your account. 1,270 is your balance. Let's see. It took 225 for, well, no, it looks like they added 225. Late fee removal. I'm trying to see how we come from, it's just the same thing.
It's confusing.
Wait, no worries. Let's see here, these are the same 2 pages, that's what that is. Okay. Monthly rent posted for 7/15. And then it looks like there was a bank transfer payment check from MSHDA for 7/14. Bringing your balance up to $1,497.
So $1 I just let take out of my account that I had in there. And that's why I frequently did with them until I found out they were stealing from me. In
Okay,
March,
sir, I
started
need you to refrain from speaking while I go over this,
Yes, ma'am.
okay?
Yes, ma'am.
Let's see, then we have a monthly charge of 7/14. Should be a check from MSHDA to cover that, okay. Then I see June, you were charged $30 for sewer. And that's what you're saying, sir, you were not,
That should.
you
on
shouldn't be
there.
charged,
Shouldn't be
okay.
on there, correct. That's my ledger, I understand, but that shouldn't be on there. And that was something I accidentally bypassed.
And so that looks like the first time I see sewer.
But on
On
their
here.
ledger, it's a whole nother story. It's every single month, all the way up to June or July, I think of this year, all the way back to November 2023. They charged me first utility as well. In their ledger.
So October 1st, I see your balance is about $2,198.90 after MSHDA sent the money. And then I see October 1st, there was an $800. Why did MSHDA only send $653?
Because that.
Oh,
month I
you're,
paid
you're,
147, just
okay,
for
what
that
you
month.
order, okay. Okay, so that brought you down to the $1,398. And then on the 21st, wrong credit from Mon account and Entrada fixed by adding rent charge. Got it. And that's your question. You want to know what that is?
Your Honor, I already know what Entrada is. It's nothing more than a software program for real estate companies. That's what they
Okay.
tried selling me. They could take my $1,400 for was a software
Okay,
program.
I've heard enough from you. Thank you. You can have a seat, counsel.
Judge, with regards to the,
Are you calling a witness?
yes, Judge. Well, I just have one question.
Yes.
With regard, so right now,
What we're dealing with is he's claiming that his $1,398.90 was taken fraudulently. That's all we're dealing with right now.
okay, thank you, Judge. Yes, Your Honor, I'd like to call Teresa Williams.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Thank you. You can have a seat.
Good morning, ma'am. I just have a few questions for you. Can you spell your name for the record, please?
Yes, first name is Teresa, Charissa, last name is Williams, Willilliams.
Okay, and do you go by any other name?
Receive occasionally, but that's just the name.
Okay. And where are you employed?
Right now with Simmons Management and Investment, also known as Flexer.
Okay. Are you working specifically for Pacific Flats, the plaintiff?
Yes,
Okay, and what is your job title there?
I'm the property manager.
Okay, and as the property manager, what are your responsibilities?
Collecting rent payments, rectifying ledgers, tenant issues and complaints, review pest control, I run all of it.
Okay, and how long have you been employed there?
Since January of 2021.
Okay, and do you maintain files on the tenants that you rent to?
Yes.
Okay, are you familiar with the defendant, Joshua Johnson?
Yes.
And he was formerly of 1421 East Kalamazoo Street, apartment number 10 in Lansing, correct?
Yes.
Are you familiar with the books and records associated with that property?
Yes.
Okay. Did you review them before testifying today?
Yes.
Okay, did you bring the tenant file today?
I did.
Okay. Did you enter into a written lease agreement with the defendant?
His lease agreement expired in 2022. We've been month to month.
Okay, there was an initial lease, correct? Do you
Correct.
remember?
That was in 2016.
Pardon?
That was in 2016.
Just,
Subject to what?
I never signed no lease with them. I only signed a lease once, and that was in 2020, 2016. I've been month to month ever since then. I've never signed a lease with them.
Okay, you can continue.
Pardon,
You
Judge?
can continue.
Oh, thank you, Judge. The original lease that he signed was dated when?
May of 2016.
Okay. And was this record made at or near the time of with the person with knowledge of the information contained in the lease?
Which record are you talking about?
The lease, Judge, I'm just setting a
Okay.
foundation to enter.
Did you
into
work
exhibit.
there in 2016?
No.
Well, then how she can testify to that? How can she?
It's in the tenant file, Your Honor, it's the books and records in the tenant file.
Your question was this record what?
When was the original lease?
May of 2016.
Okay, and would this record be kept in the normal course of the regular conducted business for the plaintiff for Pacific
Yes.
Flats?
Yes.
Okay. And is it a regular practice to keep all the tenant, okay? To keep and maintain these records?
Yes.
Your Honor, I'm going to propose the lease signed in 2016
Okay.
as proposed exhibit 1. If I may show it to the witness.
Did he see it?
That's it.
That's his copy. Okay. This is gonna be what proposed exhibit what?
1, Judge. I believe it.
This is 1.
So A.
Yours is gonna be A. Okay.
Plaintiff will do letters, Judge.
Yes. At this point, you're counter defendant, so. Counter defendant.
Oh, thank you, Judge. And may I show the defendant?
Yes.
Oh, no,
The witness.
Judge. Ms. Williams, this is document, what purports to be the lease that defendants were obligated under?
Yeah.
And did the plaintiff sign this?
I assume that is a signature, yeah.
Okay, did the, so who signed it and when?
It's quite scribbly, but I assume it is Mr. Josh Johnson's signature.
No, did the plaintiff sign it? Did Pacific
Oh,
Flats?
No, we did not own the property at that time.
Okay. Did the lease expire?
Yes,
When did it expire?
May 31st of 2017.
Okay, and did the lease term then become month to month?
I don't believe so at that time, but we didn't own the property at then, so I
Okay.
can't justify that.
Okay, and to the best of your knowledge, did he sign a new lease?
According to the record that we had, there was another lease after that. Yes.
Okay, at some point, did the lease become month to month?
Yes.
Okay, was when he was living there, was the tenancy month to month tenancy?
Yes, that started December 1st of 2022.
Okay, and did all of the rules and regulations governing the lease carry over to the month to month tenancy?
Not with the lease that was signed previously in 2016.
Okay. Your Honor, I would offer the very first lease into evidence.
Okay, let me follow up here. What rules didn't carry over?
The only thing that doesn't carry over is the actual rental amount. So like his rental amount can change because he's not locked into that lease for the month. It can change every 30 days. But with Section 8, we have to give them at least 60 days notice, which we would do.
Oh, okay, got it. Okay, you want to,
Admit that into evidence as plaintiff's exhibit A.
Is the objection to that as your
This
lease?
is the only time they ever.
No, objection as to this document being admitted as an exhibit is my question.
This first one,
Yes.
the first one is yes.
You
That's no
you're
problem.
objecting?
No,
Oh, no
I'm not.
objection.
The first
Okay, that
one,
could be
no.
admitted. Are you publishing to the court?
Yes,
At this
Judge.
time? Okay.
It's just whatever lease they're speaking of afterwards, I don't believe, because they obviously don't have.
It's not an exhibit at this point, so we can proceed, counsel.
Thank you, Judge. So you indicated that Mr. Johnson is a Section 8 recipient or voucher holder?
Correct.
Okay, and can you explain to the court what that means?
That means that usually a portion of his rent is covered by the vouchers. So we would have a portion that would be based on his income that he would need to cover for his contribution. And then whichever agency that he's dealing with for his voucher would take care of the remaining portions.
Okay, so he just pays a portion of the rent.
Correct.
And then he gets assistance with the balance, correct?
Sure.
Okay, and so that would be technically not market rent, it'd be subsidized rent? He
No.
doesn't pay market rent, correct?
He doesn't pay market rent, he pays a portion of it, but total including it, it still would be at market rent. So the actual rental amount was.
Okay, and what are his monthly obligations?
As far as
Rent. Does it change?
it can, but not usually month to month, no.
Okay, and when does that change?
Usually it would change with a lease term, but once it's month to month, under Section 8, we have to give at least 60 days notice before any rent amounts can change.
Okay, and what determines his rental amount?
It's more of a HUD guideline that would determine what his amount based on what the market rent actually is, what his voucher amount is, and what his income is.
Okay, so if he were to, for instance, make more money, his portion would increase.
Correct.
If he didn't make money, if he wasn't employed, his contribution, his own contribution would decrease, correct?
Correct.
Is there ever time it would be a zero?
Yes.
Okay, and when would that be?
Generally, if the tenant doesn't have income or if they don't have enough income to be able to support their utility allowance and a rent.
Okay, and when is the monthly rent due by?
It's due on the first of each month.
Okay, and if it's not paid by the state, is there a late fee?
No, we have a grace period through the 5th. Late charges are not assessed until the 6th.
Okay, and what is the late fee if it's not paid by the 6th?
Under the current terms of our lease, it is $50 on the 6th of each month and $100 on the 16th of the month.
Okay. And when did the defendant's rent increase? Throughout the term of the tenancy, were there increases and decreases to his portion of the rent?
Yes.
Okay, and you said that you have to give the defendant 60 days notice?
We have to give whichever agency is dealing with is the holder of their voucher. We have to give them 60 days notice
60 day notice of what?
of the increase.
Okay, and then does that adjust his portion?
Sometimes, depending on what their income is.
Okay. But that is the market rent that is increasing, correct?
Correct.
So you submit that to the voucher holder?
Yeah.
Or the voucher provider?
Yes.
And then that determines how much they pay and how much he pays,
Correct.
correct? Okay, and does this, you said fluctuates?
Yes.
Okay, and how long approximately has Mr. Johnson resided at the premises, on the premises?
He's been there since 2016.
Okay, is it fair to say that there are fluctuations both ways, increase and decrease in his portion?
Oh,
And in market rent?
yes.
Okay. Was the defendant notified of this?
Notified of the changes?
Correct.
Yes.
Okay,
Once we notify the agencies, they will send out that information to the tenant.
okay, and the new rental, when it takes effect, you would tell them that as well?
Correct.
Okay, and you would tell the voucher provider as well?
Correct.
Okay. With regards to, is there a month-to-month fee?
Yes,
How much is that?
it's generally an increase in the rent charge of 1.2%.
Okay, so that is because he doesn't have a term period of 12 months, is that correct?
Correct.
Okay, and that is a percentage based on
Market rent.
market rent, okay. With regards to utility allowances.
Mhm.
Okay, defendant, counter plaintiff, furnish the court with a request for tenant fee approval
Mhm.
And Judge, this, it wasn't numbered, but it indicates this where O is the owner.
Correct.
T is the tenant.
Correct.
And who is responsible for what utility?
Correct.
Okay, and how long is this good for?
We call them RIFTAs. They are valid for the
I'm
term.
sorry, what's it called?
It's short RIFTA, RFTA, request for tenancy approval.
Okay,
Those are valid for essentially the term of the lease, which would be for the year, and then every year with renewals, we have to send another one.
okay, so is it fair to say that utility allowances change?
Absolutely.
Okay, is it fair to say that the person responsible for who pays for the utilities changes?
Absolutely.
Okay, and at what date did Mr. Johnson become responsible for the gas?
Gas is still was never responsible for. Gas was always still going to be under ours. The only change was to water, sewer, and trash.
Okay, and when was that change?
That change originally was in, sorry, I did a blanket one for the whole company. The first one was in June of 2024.
Okay, and that changed for water, sewage, trash to be the responsibility of Mr. Johnson, is that correct?
Correct.
Okay, so the initial one that he gave to the court dated April 22nd, 2016 is no longer valid, correct?
Correct, because that lease was no longer valid.
Okay,
Do you have proof that he was, where's the one that showed him? Because that's his. Where is the one, what is this called, a RIFTA?
Yes,
Where's the
RIFTA,
RIFTA that notified him that he would now be, or MISHA, that he would be responsible?
no, that was actually as a company that sent all that information to both of the agencies on February 28th of last year, notifying.
Of
all the agencies-
2024?
Correct, that we were changing the way that water, sewer, and trash was being billed, just so that we could get all of our Section 8 tenants across the board encompassed.
And so that would, my question is so if that was sent to MISHA, then MISHA would send an adjustment notification, and now his allowance would indicate that?
They should have, yes,
Okay, thank you.
and what year was this?
2024.
So in 2024, when you notified MISHA, who then is responsible? Would it be MISHA's responsibility to pay for the utilities, or would it be Mr. Johnson's responsibility to pay for the?
It was dependent upon what the tenant's contribution was. So with both MISHA and LHC, we were dealing with.
I'm sorry, LHC, what is that?
Sorry, I'm
stand
sorry,
for?
LHC is Lansing Housing Commission.
Okay, Lansing Housing Commission.
Yes,
So, and MISHA is,
Michigan State Housing and Development Authority.
okay, continue.
For both agencies, we were essentially just kind of piecing it out. So on Mr. Johnson's ledger, where it shows that the $40 water, sewer, and then the $10 in trash, that was simply our accounting, just pulling it out so that we could track utility allotments versus what the actual rent charge, but his rent charge amount was completely totaled with LHC. It would still be exact same.
So you did not charge more, is that correct?
That is correct.
Okay. So Mr. Johnson is contesting the charges on the ledger.
Mhm.
Can you speak to
Is that a
that?
yes?
I'm sorry, yes.
I'm sorry, contesting on the ledger. Will you address that?
The 1398.90.
The utility allowances or
Oh.
the utility charges, pardon.
Yes, the utility charges were simply added more for tracking on the back end of our side, just so that we could count what was actually going, or what was being charged for water, sewer, trash versus what was being charged for actual rent charges. The actual total amount that he was being charged did not change.
Okay, so he was not being charged this amount, correct?
Correct.
Okay. And
Okay, let me just stop. Because I'm confused. No,
I'm sorry,
no.
sorry.
You said that your company sent notification out in 2024.
Correct.
That there was gonna now be responsibility on the renter to pay water, trash, and sewage, correct?
Correct.
Why am I looking at your ledger that says there's a monthly water sewer postage of $40 and it's in 2023?
Because Mr. Johnson went month to month in 2022, so his lease essentially renewed every 30 days. This was not necessarily the same as our tenants who have a 12-month lease with us.
Well, I asked prior to that, where's the RIPTA that notified him that that was gonna be added?
I don't have that with me.
But his original lease stated that the landlord would pay that, correct?
Correct.
And then the rifter that he provided states that, again, the landlord is gonna pay that, correct?
Correct.
Okay, but no evidence that Mishta or Key was notified as of a certain date prior to November 2023, that he would now be responsible for that.
Even the old lady.
And Judge, can you repeat that question one more time, Judge?
No evidence that Mishta or Mr. Johnson was notified somewhere around November 2023, where I see this now on his on the ledger that you have, like, I guess he said that you provided, that he would now be responsible for water and sewer, because that's on that ledger.
Your Honor, just
Not
like,
right now. Write your questions and things down so that when it's your turn.
I got it written down.
Okay.
Judge, I believe you requested
Wherever,
notice.
yeah, notice to Mishta and the tenant that he would now be responsible for.
I didn't even see it. This one I recognize, but this, never seen this. When was this even based on? What was the dates? 2023, 580 month? Yeah. Was even being charged 580 a month in 2023. In my ledger, it shows I was charged 715. So this isn't right. The numbers don't add up, Your Honor.
I don't know what is that you're proposing, ma'am?
Numbers don't add.
Notice of rent increase for 2024 and Mr. Johnson's water sewage trash charge. And that was
What's the
40
date on
for
that?
water and sewer and 10 for trash.
What's the date for that?
September 20th, 2023.
And yet they're saying I'm paying
But,
500.
sir,
Oh, Judge, I'm sorry, may I show the defense?
yes.
Oh,
The witness.
The witness.
But I've never seen that.
Okay, so you're saying you never received that?
That's correct. I
Okay,
have
you
proof
can
of that
write,
as well.
write notes so that you can address it when it's your turn.
Ma'am, can you indicate to the court what that document is and what it contains?
Yes, this is generated when we do a lease renewal. So this was very likely an attempt to get Mr. Johnson to sign another lease, and these would have been the terms at the time.
Okay, and at that time, who does it indicate would be responsible for water, sewage, trash?
To the tenant.
Okay, and what date was that?
This is dated for September 20th of 2023.
Okay, so if there is no lease in place and it's a month-to-month tenancy, he would be responsible for water, sewage, trash. Is that correct?
That's correct.
Okay, and that was the notice that you sent to Mr. Johnson.
Correct. Along with that information was sent to Lansing Housing Commission. We have to give them 60 days notice.
Okay, and the second document that you have in front of you, is that a rent increase?
Yes,
Okay, and what was the date on that and how much was it for?
it was dated for November 4th of 2024, indicating that the rent charge was going from 800 to 960 with it being monthly.
Thank you. Judge, and I would ask that that be per your request, that the notice is
You're asking to do what?
admit that as exhibit B as in boy.
Exhibit B to these
Those
together
two.
as one, okay.
Thank you.
Okay, so this again is a notice of rental increase and new lease. This is from November 24th, 2024. However, my question was about November 2023, because that's when he was being assessed.
Correct. So they have to give 60 days notice, Judge. And that was in fact in September, and then that increase would take place in November of 2020.
Well, this one, these are two separate, this is from November of 2024, it's a year later.
For the rent
Sorry.
increase for the utilities.
These are two separate documents. I
Right, so it
can't
would
make
be
them
to
one
your left.
exhibit then. Because this is from November 4th, 2024. These are over a year apart. They can't be one document.
Then I would move to put that as exhibit 3, Judge.
This
Or
one exhibit
C.
B, this is B, this is C. Okay, so B, give me
I
a.
don't have it here. She took them back.
Okay, this is Good Life Lansing residentportal.com. This is not a notification here though, ma'am. This is just something that was printed off of a portal, correct?
Correct.
This would not be notification that was sent to someone, because that would come in a letter form, correct?
Correct.
Okay. So. I don't know if you have a letter, but this is not a letter notifying Mr. or the tenant of a rental increase. This is just from the goodlife.com resident portal, which it says it on the top. And it says here that something's assessed, but that's not notification 60 days prior to him or to Mishta that he's going to be assessed for those charges.
Ma'am, was
That one's gonna be B, and that one's C. No, this one's B.
Can I just address why we added the rent charge of the $13.98?
Well, you can't, they ask, you can only address questions.
right, there's two
That are asked.
things that he's objecting to, the utilities and the 1398.
Okay.
We're just dealing with utilities right now.
With regards to utilities, did you notify the Housing Commission of the increase with regards to utilities?
With the change in how it was billed, yes, it was not an increase. It was still the same amount as our other things had already changed.
Okay, and then did you notify Mishta?
Yes.
Did you notify Mr. Johnson?
Yeah.
Okay, and do you have the letter notification with you here today?
No.
Okay, and were you anticipating this as a point of contention today?
No.
Okay, is that why you don't have it?
Correct.
Could you, in any other means, provide it to the court today?
Yes.
Okay, so if you could email or call someone, we could have that notification sent to the court,
Very likely, yes.
but one does exist, correct? And when did that notice go out?
I would have to look at it to give you the exact date.
Okay, would it be 60 days before
It
it
has to
took
be-
into,
It has to be at least 60 days. So if we send it like the middle of November, it can't take effect until February.
okay,
Because it has to be at least 60 days.
Judge, because we didn't know exactly what the narrowed down issues were, I would ask that we have the opportunity to have that information back to the court, providing the notice to the defendant, to Mishta, and to Lansing Housing Commission with regards to the increase.
I can pull the actual transcript if necessary, but I'm confident in more than one time he's mentioned sewer and water charges in this courtroom that he was not supposed to be responsible for. This is not the first time he's mentioned that in this court. I don't know why, at bare minimum, the money in his account, he's mentioned that prior to today. And he said that being charged fees that he should have been charged for, why that would not have been anticipated for today. And today was the time to prove that what his rent was and what he owed to dispute the basis of why the money was taken out of the account. So I think it's reasonable that would have brought evidence of whenever his rent was changed. He brought a bunch of different documents from Mishta. They're saying that they notified him of this was the change of your rent. Why would we not have that?
Just because in his pleadings, he's pleading emotional distress and fraud, misappropriation. Nothing says, hey, I contest utilities being charged erroneously or rent being removed. This is
he said that on the record when we had the motion that I did on the record, and I said, what were the specific issues? He made it clear on this record, we could pull the transcript, that there was money that he had in his account that was taken out. So we knew that was an issue before we came here today, before he opened his mouth today. We knew it was an issue that he was alleging that there was some fees that he had been charged for in his account that he believed he should not have been charged for. So anything on your ledger, I believe, was reasonably notified to you that you should have been able to have your client provide documents. If this is what his rent was, this is how much it was, these are the times that it changed, and this is when we notified Mishta that it was going to be changed. And it may have been a lot of times because he was month to month, but I think that's reasonable. This is for, he's saying that money he had in his rent account was taken out.
Judge, respectfully, I disagree. I don't recall the utilities being an issue. But we do have proof that notice was sent to all three parties with regards to the increase in the charging of the utilities.
Okay, you can continue.
Yeah, with regards to the charge of $1,398, in the ledger that Mr. Johnson provided, which indicated was quote unquote his ledger, there was a deduction of $1,398. Oh, and 90 cents. I apologize. And it indicated wrong credit from MON account in Entrata fixed by adding a rent charge. Will you indicate to the judge or to the court what that accounting is or what that entry is?
Yes, MON, for clarification, is for Monopoly Apartments LLC. It's the entity that Pacific Collects is owned by. In auditing records and just looking back at literally every account, not just Mr. Johnson's, we went through every account that we had, just looking at credits, looking at large balances, just to verify if everything was correct. There was an issue with his rent charges. The Section 8 was notified of his rent increase in 2023, that it was at $715. We were only charging him $515 in our system. With finding that error, we went back and added the rent charges. Mr. Johnson actually ended up owing us a little bit over $600, but we just zeroed out the credit to keep everything even.
Okay, you said that you went back and determined that he was supposed to be paying how much when?
The total rent should have been $715, but we were only charging $515. I don't know if you have that exhibit just yet.
I have a ledger, but this ledger is telling me back to 2024. So
correct. There is another one from before that as well.
This must be the one I never forget from him.
This is the one that I gave you that you gave to Joe.
We don't go back and forth. We're not disputing. You can only respond to questions, ma'am. I don't know if your attorney told you that. You're saying prior to November 1st, 2023, his rent should have been.
This is the 2023 ledger, Judge.
2023 ledger. Okay.
It was changed softwares, so there was a difference in the ledger.
When you see there's a difference in the ledgers, you mean like
And just what it looks like.
the
Essentially
physical,
just what it looks like.
right, but not the content of it, correct?
Since you tell me, can you tell me when his rent was supposed to be?
I have that back now.
Okay. Because I do see here too, from Mr. Adjustment, it says February 22nd, 2023 to May 31st, 2023, rent was $715. So Mr. was paying you $715, correct?
But we were only charging $515 at the time. in our actual system.
I don't recognize this, Your Honor.
Judge, can I show the
I've never
witness-
seen
the
that either.
witness?
Yes, please.
This will be proposed exhibit D, Judge.
So it was not 515, it was 580 that we were charging instead of the 750.
So you should have been charging what, ma'am?
$715,
But what were you erroneously charging?
580.
Okay, and who is responsible for the difference?
Honestly, no one is responsible for the difference. That was just an accounting error on our part. We should have been charging 715, and then he would have just been responsible for, I think his contribution at the time was $1 or $2, but we were not actually charging it. In going back, we added the rent charges that we should have been adding. It was not a rainy day fund of a credit. It was the credit building up from the rent charges not being correct.
Okay, so Mr.
But let me stop you. Let me just want to clarify. So you're saying that the money that was building up was not because he was transferring money from his personal account?
Correct. He has never made a payment to me.
You're
Yes,
moving to
Judge.
admit this?
Yes, please.
Okay.
Exhibit D. So let's just clarify. Mr. Johnson wasn't depositing money, cash, money order, certified checks, credit cards, anything of that nature to his account, correct?
That is correct.
So the balance where it's in parentheses, where it shows as credit, where did that come from?
That was from the error of us not charging the correct amount. We were getting the deposits of $713 to $715, but we were only charging 580. So it was building up a credit.
Okay, so at no time did he deposit money into the account?
Correct.
Okay, and so anything, for lack of better words, extra was an, you're undercharging of the market rent, correct?
Correct.
So when Mr. Johnson alleges that this money was his money, that is incorrect as in regards to him paying into.
Correct. Anything that would have been extra would have gone back to the Lansing Housing Commission. If it was an actual credit.
Let me just ask a random question. Do you allow tenants to pay extra in there?
Yeah, and
Oh,
it'll just sit as a credit on their account. So like
Okay.
if a tenant wants to pay 2 months at a time, then they'll just let it sit as a credit.
So if I'm looking at this ledger that he provided, like, let me see. This is the one he
Oh,
provided?
okay.
Yeah, and it says like at the top of yours is the first thing, November 1st, 2024.
I have November 6th, 2024, Judge.
The date at the top, I think she said.
Oh, yeah, I meant the first transaction.
Oh, yes, Judge.
Okay, and so the first transaction I see is from Mishta.
Correct.
If he were to make a payment, what should it look, what's
It would say check 21.
check 21? Okay, thank you.
So anytime Mishta makes a payment, it is classified under Mishta making the payment.
Correct.
So you can identify quickly who made the payment and in what amount.
Correct.
Okay. Are there any entries on anyone's ledger that shows Mr. Johnson's payment into the account?
No.
Okay. And to the best of your knowledge, he's not paid into the account, correct?
Correct.
Off the record, just a moment. You can be seated. The plaintiff never showed up, so the case is gonna be dismissed. I'll get you a dismissal in just a moment.
Okay, great. Thank you. All right.
You can proceed, counsel.
Oh, okay, thank you. Ma'am, when did Mr. Johnson vacate the unit?
August 4th, I believe the date was. It was a
Okay.
Monday.
And prior to August 4th, had he been paying rent?
Was section 8 paying rent? Yes.
Okay, so section 8 pays their portion, regardless of whether or not Mr. Johnson pays his portion.
Correct.
Okay, so when was the last time Mr. Johnson paid his portion?
I've worked there since January. I've never received a payment from him.
Counsel, can you ask about the bed bug fee if you know? I don't know if she was
I do
there.
know, I do know about that.
With regards to a charge for,
$405.
looks like $405 charged March 21st, 2024. For a bed bug issue. Can you address that, please?
Yes, Mr. Johnson was given information to prep for the treatment notification that there were the unit.
Okay, I'm sorry. Pardon?
I'm sorry, after notification, that after us receiving notification of the pest in his unit, the pest control company that we were utilizing at the time came out and Mr. Johnson refused to let them in. We, of course, let him know that if he refused, he was going to receive the charge, the trip charge for them coming out and not being able to complete the contract.
Okay. And were you charged that regardless of whether or not they actually treated the unit?
Yes, because they actually came to treat the unit and did not actually do so because he refused to let them.
Okay. And how much were you charged, ma'am?
$405.
Regards to a March 22nd, 2024 entry of bad debt write-off. Mr. current half is $715, Mr. portion $714, tenant portion $1 rent was increased to $850 without proper notice to tenant or Mr. Can you speak to that, please?
Was that a credit or a charge?
It was a credit. It's in parentheses, $675.
Yes,
I believe you had a question about that.
correct. In again, auditing ledgers, then there was a realization that Section 8 was not notified with a 60-day notice of his rent increase, so we had to back off the rent charges that were increased over that time.
Say that one more time.
There was, in auditing the records, there was a point where Section 8 had not been notified 60 days out of a rent increase, so we had to back off the rent charges that were inaccurately added, so we had to take off that 600 and something dollars.
Back to the back to the ledger. So Mr. Johnson has not paid his rental portion since January, correct?
Not the entire time I've worked there, no.
Okay, and do you know what his rental portion is?
I do not know what it is. Well, I don't know what it is now. He's no longer living on our property.
Okay, and at some point, did Mr. Johnson acquire a pet?
Yes.
Okay, do you know what that pet was
It was
or
a dog.
is? Okay. And prior to that, Did you know about the pet?
We were not notified.
You were not notified. And how did you come to find out about this pet?
We happened upon the unit and found the dog.
What do you mean you happened upon?
In our regular walks with pest control, we're coming in for maintenance, we regularly go into tenants.
Okay, and then you came across a dog.
Yes,
How do you know it was a tenant's dog?
we asked.
And he indicated to you
that it was his
personally?
dog, yes.
Okay, and did he pay a pet deposit for the dog?
There's supposed to be a $200 pet deposit along with monthly rent for the pet.
Monthly?
A monthly pet rent of $35 this year.
You
Okay,
said a monthly pet,
Monthly pet rent of $35.
okay, so $200 pet deposit and then monthly of 30.
Correct. The only time that is not assessed is if they have a valid ESA letter and provide that.
okay, ESA is emotional support animal or
Correct.
service animal, correct?
Correct.
Okay, and did he provide, make a reasonable accommodation request to you?
We did not.
Okay, did he provide any letters, stating that was a service animal or ESA?
We did not.
Okay, and then do you charge them the pet fees?
Correct.
Okay, do you, charge, how much do you say per month?
35.
Okay. Are there any other, fees associated with the pets? At any time was his rent abated and why?
Yes. His rent was abated due to a failed HQS inspection, meaning
What is that?
a failed HQF inspection with Section 8, meaning if Section 8 comes for an inspection and there are items that they deem are broken or are safety hazards and we have to fix them. If we do not fix them within, I believe we have 30 days, then his rent would get abated, meaning that Section 8 will stop payment and we essentially have to write off that.
Okay, did at any time Mr. Johnson make any repair requests, work orders, or maintenance requests?
Not in relation to the failed inspection. We were never notified of the inspection, and for whatever reason, we never received the mailing from the Lansing Housing Commission regarding it either until the rent was abated and realized that there was an issue.
Okay, but the issues that made you fail the inspection, there were no requests made to address those issues, is that correct?
Not prior to the inspection, no.
And whose responsibility is it to make requests if needed?
It is the tenant's responsibility.
Okay, and would you be aware of any requests or maintenance issues that were needed?
Yes, we have a crazy level of oversight. I get an email for every work order that's entered on any of my properties.
Okay, so you personally would know if someone was requesting their unit be inspected or
Yes.
repaired or maintenance issues?
Absolutely.
Okay, and did Mr. Johnson place any?
No.
If he did, it would be in your tenant file, correct?
Correct.
And you would deploy the necessary person to make those repairs?
Correct.
Okay.
What, do you know what was the issue that caused the abatement?
Long story short, we were never notified of the inspection, but once we received the information as to what needed to be fixed on the inspection, then it became an issue of actually entering the unit. My maintenance techs would go to the.
No, I mean, like, what
What
needed
were
to be
the actual
fixed?
issues? Yeah, like there was in his refrigerator, there was 2 missing drawers, but he happened to have a really old refrigerator, so we ended up just getting a completely new refrigerator to replace it. We couldn't find the shelving. There was an issue with some peeling wood on the bathroom door, and on the bedroom door, I believe there was, I think his air conditioner was leaking. There was a few issues.
Okay, so things that you wouldn't it wasn't like a water heater or something like
No,
that?
no.
Okay, thank you.
How about it split
Look,
door, split front door?
We don't do that. Yeah, I told you already,
I understand.
don't blurt out.
Okay, okay.
When you were testifying, she was not allowed to speak.
I'm so
Okay.
sorry. I'm doing my
Thank
best.
you. You can proceed.
There was also an issue of pest control was listed on there for pest activity, but our units are always on regular rotation, and our pest control technician notes if there's any activity in the unit, along with if there's any sanitation issues that could contribute to there being activity,
Pest activity like,
like cockroaches.
oh, okay, got it.
So when the rent is abated, both the voucher provider, the voucher holder, no one is responsible for the rent during that period, is that correct?
That is correct.
Okay, would that be assessed to the ledger?
Yes. Absolutely, like the abatement amount?
Yes.
Yes,
Okay, and did you at any time abate, and how much did you?
I did. I don't exactly remember the exact dollar amount. I believe it was in the realm of $2,000.
Okay, and Did those issues that you indicated to the court earlier, the reasons why you failed inspection, were they rectified?
Yes,
Okay, and you said something about access to the unit.
yes. The reason the abatement lasted so long was because the first few attempts by my maintenance personnel that were going to the unit, Mr. Johnson would say, I don't want you in my unit without me being here, which is 100% his right, but it was continuous so that we couldn't get into actually do the inspections. So I reached out to the Lansing Housing Commission, then she stated that she let me know, as well as Mr. Johnson, that he cannot deny us access when it comes to inspection collections.
Okay, so he didn't deny you inspections. He just wanted to be present at the time.
Correct.
Okay, and he did not make himself present for these inspections.
The first few times, yes.
And few as in how many?
At least 3.
Okay. And you can't access this unit without him present, is that correct?
We can, yes, but we were trying to be respectful because he wanted to be present while we were doing the collection.
So all the corrections were made?
Yes,
Did you pass inspection later?
yes,
Okay, and then the payments resume after?
after the inspection is passed.
Okay, so the abatement was just for that period of time, is that correct?
Correct.
Okay. Judge, I just have a few more questions. Actually, Judge, I believe that, oh, sorry. Judge, I'm moving to admit Exhibit E as an elephant, showing that now it's the current ledger.
I don't even have this, of course. There's no reason why I should have that balance at all.
May I show the witness?
I
Judge?
don't have a
Yes.
copy of that either, so.
Ma'am, is that the defendant's current ledger?
Yes.
Kept in the normal course of business?
Yes,
And is the amount due at this time, if you could read it to the court?
it's $3,822.32.
And that consists of Mr. Johnson's portion?
Correct.
Okay, late fees?
Correct.
And
And
Pet
the
fees.
pet fees, correct.
and the late fees again are how much per month?
Under our current terms is $50, or for Mr. Johnson, I apologize, it's $50 on the 6th of the month and $25 on the 16th.
Okay, and when was the last time Mr. Johnson had zero balance?
Would have been November 1st of 2024.
Okay, and since November 1st of 2024, what has been assessed to his account that is his responsibility?
The utilities, as in water, sewer, trash, the pets.
Since November of 2024?
Correct. His actual rental amounts, which actually Section 8 is taking care of a good portion of it, but there was a time
Okay,
where he
and
was
can
supposed to
you
be paying
indicate to the court what's assessed and at what date?
for each month,
Correct.
starting when?
Starting when he had a zero balance.
November 1, rent charge of $800.
Excuse me, go ahead, I'm sorry.
Sorry, rent charge of $800, water sewer charge of $40, trash $10. He received a $50 credit because there was an issue with the boiler in that building, so I gave everyone a $50 credit on the rent. Next one,
Yes.
sorry, December 1 of 2024, rent charge of $800, water sewer of $40, trash of $10. We received a payment from Mishta of $800.
And don't include legal fees in there, just continue.
Next charge was December 26th of 2024, when we discovered the pet in his unit, along with the prorated pet rent of $1.13 for that month. January 1 of 2025, pet fees of $35. That was the month he increased to the month-to-month amount of $960. Water sewer of $40, trash of $10. We received a payment from Mishta for $948. With the balance still being at $449.13, he was assessed a late charge of $50 on the 6th of January and a $25 late charge on the 16th of January. We received a $12 payment from Mr. Johnson on January 30th.
Yes, please.
February 1, 2025, water sewer charge of $40, trash charge of $10, pet rent of $35, monthly rent of $960. This was the first month that rent was abated. We did not receive a payment. We have late charges of $50 on February 6th. Late charge
Okay,
of,
no, I'm sorry. No, the late charges carry over if there's a balance. Is that correct?
correct,
Okay, so whatever there, it would continue to roll over until the next month, ma'am?
correct.
Okay, I'm sorry, please continue.
March 1 of 2025, rent charge of $960, water sewer of $35, pet rent of $35, trash $10. March 6th, late charge of $50, March 16th, late charge of $25. April 1, water sewer $40, trash $10, rent charge $960, pet rent of $35. Late charge on April 6th of $50, late charge of $25 on the 16th of April. May 1, exactly the same, pet rent $35, water sewer $40, $10 in trash, $960 rent charge. Late charge of $50 on May 6th. May 9th of 2025, we abated $2,110 and removed that because the rent was actually abated for the failed HQS inspection. May 15th, we received a payment of $948. I'm sorry, one payment of $948 along with a prorated amount of $734 from Michigan. May 16th, late charge of $25, being that there's still a balance on the account. June 1, $10 for trash, $40 for water sewer, $35 for pets, $960 in rent charge. Received a payment from Mishta on June 3rd of $798. June 6th, late charge of $50, June 16th, late charge of $25. July 1, water sewer, $40, trash $10, pet fees of $35, $960 in rent. July 3rd, we received a payment from Mishta for $798. Late charge on July 6th of $50, late charge July 16th of $25. August 1, being that he moved out, it was prorated, so there was a rent charge of $123.87, water sewer of $5.16, pet fee of $4.52, trash of $1.29. When upon move out, there's $250 cleaning fee for cleaning the unit afterwards. That was assessed on August 4th upon move out. The security deposit of $515 along with the $200 security deposit for the pet was applied on August 6th, leaving the balance of $3,822.35.
Okay, so if we remove the legal fees that are assessed to the ledger, is the balance $1,584.01 that is due and owing?
Yes.
Okay, Judge, I will move to admit that as a plaintiff. I believe that's exhibit E.
Any objection?
I do object.
What do you object to as a part of that ledger?
As far as that ledger goes, well, from very many of them.
Well, not that you dispute the ledger, but are you saying that this is not the ledger that they kept in the regular course of business?
I wouldn't know if they did or not.
So I'll note your objection, but
Okay.
it will be
Thank you.
overruled. Okay. Okay, let's see. Any other questions for this one?
No, Judge.
You have questions for this witness?
Yes, yes, I do. You state that you gave LHC a written request notifying them of more than just my rent increase. Is that correct? That included the utilities as well in June of 2025? Is that correct?
I did not say June 2025, no.
Okay, you did say it when you did you said that you gave them notice in, well, you said you gave them notice. Correct, that you increase my rent, or that you increase my rent and that you increase, or you add utilities as well to it, correct?
Correct.
I'd like to, actually, Your Honor, you have a Exhibit A is the email from Cammy that states only the rent was what was discussed in both emails.
Are you
from
asking
Pacific Flex.
her a question?
Yep, correct. So
I'm sorry,
why was there no indication of an increase in utilities as well?
As I stated previously, it was sent out as a blanket information to all of the agencies that we deal with for Section 8. It did not go personally to Cammy.
Okay, Cammy does not have anything in my file and it explains it.
I
in the
can't
email.
speak, I can't, we
Okay.
can't speak on behalf of Cammy. Cammy's not here.
Okay. We could always call her, of course, absolutely. She'd be more than happy to
No,
suspend.
we can't call her because she was supposed to be
Okay.
subpoenaed here today. We
Okay,
wanted her to
so
testify.
I have the proof in that letter that shows that she only asked for rent increase for June and for no.
I'm not sure what letter you're referencing.
It's the email from Cammy Sutton from LHC. The email.
We're talking about an email from 2025.
The one that's from Cammy Sutton, it's the only email that you should have up there. It's in yellow marking. It should say that she had looked through her files and everything on me for the time I've been there. And the only thing she had was no updated lease.
Okay, you can ask your next question.
Okay, okay. Next question. I have email in my phone stating that Cammy has told me that mail has been sent back to her from the apartments.
I checked on 2 counts.
I don't know what the question is yet. What's the question?
So my question is, you state that you did give me, or sorry, that you did say that LHC sent me something, correct? That's what you said?
Your question to her, to this witness is
That
did she
LHC
say that?
The LHC did say that, or she said the LHC sent me the copy of everything that she said as far as this whole entire time is gone. Everything she says she sent to LHC is sent to me? Because
I'm not following your question.
Are you agreeing that you said the LHC gave me all the paperwork and all the updates that you yourself gave to LHC?
I said it is standard for any updates that we send to our agencies that the agencies send out to their tenants. Yes.
Okay, I did not get anything because LHC claims that they got my mail back to them. So my mail did get to me, so I don't understand why the issue is that certain LHC paperwork is getting sent back to them. Now, landlord has a key to my mailbox.
No, this is time to give questions
Okay.
for this
So
witness,
then-
not argument.
So then there was nothing given back to me. That's the point I wanted to make. I have an email. I'm sorry. I need to rephrase this. Oh, that was the only thing at least. Okay, I already asked her that. Oh, yes. Okay. You say that LHC was overpaying you for those years in 2022, all the way up until you said 2023, correct?
No, I did not say that. I said they
Okay.
were not correctly charging rent. They were not.
You said it was the
overpaying.
opposite, that they were underpaying.
Correct.
They were
No, they were
underpaid.
not underpaying. We were undercharging.
Got it, okay.
And you said you were charging me $580?
Correct.
I have here, Your Honor, it says
Is
that
this for the witness?
it's proof that she was lying. The LHC.
You have to ask her about your proof. I don't just take exhibits.
I have proof here that says LHC pays 573 from 1/1/2022 all the way up to 5/01/2022, and then it changed to 390 and 6/01/22, 390 for 3 months, 188, 578 to 713 to 424.
What is it that you're looking at, sir?
This is the numbers from LEC that I had given you earlier as well too. Those,
So you want the witness
I
to
would
see
like
that?
her,
You
yep,
can provide that to the
and say
witness,
that is not the
And
case.
can you tell me, do you know what this is, ma'am?
I do. It is essentially a ledger from the Lansing Housing Commission stating how much the HAP payment was that they were actually sending to us. It does confirm that they were paying $713 starting January 2023, where we were still only charging $580.
Any other questions for this witness?
Yep, I do. You stated that I've never made a payment to you whatsoever. The whole time you've been there. You said that under oath, correct? I never made a payment to you whatsoever.
Upon looking at the ledger with some sheet, I did see that $112 payment from January of 2025.
I'd like to exhibit this as proof that I did pay them in February
is
of
this?
2025. This is the receipt
Of what?
for
Well,
payment.
ask her, how much are you alleging you paid and how, and when, and ask her if she ever received that payment.
Did you ever receive a payment from me for $12 in February of 2025?
I did not. I received it on January 30th. I just got that.
January 30th, for February.
Yes,
But you knew it
very-
was for
very
February.
likely
You
for-
knew it was for February.
Are we, no arguments? Okay,
All right, all right. So there was one, correct?
Yes.
Okay, thank you. The violations that you state. You say that I have had the dog since when?
December 26th of 2024.
Okay, I'll agree, that's right. Do you remember what it was I told you the reason why I got the dog? You remember what it was I told you?
I never had a conversation. with
Okay,
her.
okay. Your Honor, I had a conversation with her.
when you, this is not the time to give your argument. This
Gotcha.
is, you can,
So I gotta
after you
remember
finish
all
questioning.
this. I gotta
Okay.
remember it all too.
Okay, got it. So you want to address what, the dog thing?
Yes, correct, because I have PTSD and
Okay.
my door, you can see in these pictures, is split wide open. I've had squatters and crackheads trying to get into my apartment.
How did your door get split?
No idea. I came home one weekend and somebody was trying to break into my apartment.
Okay, you
They
called
have
the
had
police?
a lot
Did
of
you
issues.
call the police? Is there a police report?
I believe I did. I believe. I'm not
You
100%.
believe you came, you
No.
brought all this evidence, you don't believe it?
No,
You don't
no,
know if
no.
There's a police report?
I don't remember actually calling the police, but I do know that I had this issue. I came home the weekend and it looked like it'd been split. I don't know what they had done. I don't know what had happened. There's no cameras. I can't prove anything. The cops would tell me, you weren't even here. Talk to the
You
landlord.
can't, we hearsay, we don't know what we don't, and that causes
But the-
speculation. We don't know what a cop would say. You are telling me
Okay.
that you came home and it looked like your door had been split and that someone tried to break in and you did not call the police.
No, that is correct.
Okay,
That is correct. So I needed a
Did you
dog for
notify-
protection. I
did you know-
notified them.
did you notify your property manager that your door looked like it had been split?
That's correct.
How
They
did you
know.
notify them?
I told them in person.
Who did you talk to?
I talked to her.
Okay, you recall that, ma'am?
No.
Okay.
Very likely spoke to
What
my
day was
assistant at the
this?
time.
This was in December on, I want to say.
December
right,
2024?
December 2nd, maybe the 3rd. It was right at the very beginning of December. It was right at the very beginning of December. I
This
told
past
her-
December
Yes,
2024?
yes, because I had the issue with that door and I've been trying to get after them for months to fix this problem. And for months they wouldn't. So I had to get LHC to come and do an early inspection to get them to do their repairs.
When did they
And
come to the inspection?
When the January 24th of 2025.
Okay, was the door an issue then?
We had not been notified about the
Yes.
door, but upon the inspection, the door was an issue, yes.
Okay, and the door was repaired after
It was-
January?
yes.
Okay, and when did you get the dog?
I got the dog in December because.
December what?
December before Christmas.
Okay,
the
so, okay, 2024, you got a dog.
Yes, correct.
Okay, keep
So I
going.
don't deny the dog, but I needed the dog because they wouldn't do their part. They
Well-
would not fix anything. And
You needed a dog because they wouldn't
because
fix the door?
they're crackheads and the stuff. And
What kind of dog did you get? sir?
I had a dog that was,
What's the-
it was just a mix of something.
Mix of what?
It was a Heinz 57. Heinz 57. It's like an American Bulldog. Boston Terrier.
Okay,
I mean, a lot of different mixes. I couldn't tell you exactly what she might have been.
it was not a puppy when you got it?
No, she was not a puppy.
Okay.
No, correct. She was
And
not a
did
puppy.
you
She was
notify
3,
your
4 years
your
old.
landlord that you were getting a dog?
That's correct.
How
That's
did you
correct.
notify them?
I told, again, in person. I
Did you
told
pay
them
the
in person.
fee to have a dog?
I told them I'm getting the dog because of the door. They
Did
will
you-
not fix the door, so I need to
I
get a
understand.
dog.
Did you pay the fee to get the dog?
No, no, I did not. Okay, so really, these are more just proof than they are asking her anything. I'm not gonna really get anywhere with her. This is just more proof to show that what they said between them, a lot of it are lies. And I can prove
What is this is just proof?
They
I'm
are
not sure what you're talking about.
that the questions I'm asking are more so me being able to prove what they said is a lie. More
Okay, so
so
you don't
than
have any
me
more
asking
questions. You
her
don't have any
questions.
more questions for her then? Okay, very good. You can be excused.
Yeah, absolutely.
Okay, now you can continue with your
Okay.
evidence.
Okay, all right, so, well, with the, dates that they said with LHC was giving them the same amount exactly that they were asking for.
Well, I have the records
2022.
of what they, I'm not disputing that LHC paid whatever they paid. Show me proof that you deposited money into the account out of your personal account. Show me your evidence for that.
Okay, that's just throughout my ledger. That is what I
Nothing
was,
on your ledger shows me where you deposited money.
as you look through the months, it will show different amounts and then it adds up.
I see the different amounts, but show
Okay.
me where it came from you, because that's not, I don't see anything that came from you.
Okay, the only thing that I can show you is I sent them this right here. This is the only thing
That was
that I have a
in
copy of.
January of this year.
No, well, yes, January 31st, February.
So you told me that you put $1,398 in your account for safekeeping. When did you put show me where you took $1,398 out of your banking
I
account
wouldn't be able to do that.
and 90 cents and put it
I
into
couldn't
this
do that.
account?
I couldn't do
What do you
that,
mean?
Your
Why
Honor.
can't
I
you
wouldn't
do
be able
that?
to do that. All I have is my ledger. That is what I went on proof. of,
Why
is my ledger.
can't you, why don't you have proof that it came out of your account?
Because I have no account. That's why I was putting extra money into the rental account. So that way I have no account. I don't want to leave my money in.
You say you don't have a bank account? is
No,
what
I
you're
don't
saying?
have no bank.
So
account, no.
how did you get the money into the
By
rent
giving
account?
it to them, by giving it to them.
You had, so you're saying you had cash
Yes, yes.
and you walked
yes,
over
and I
to
gave
them
it to
and gave it to them?
That's correct. That's
And
correct.
you didn't get a receipt?
They didn't give me a receipt, no. No, they didn't give me a receipt. Sometimes they did, sometimes they didn't. This is going back
Where's
way
the,
in
well, okay, if they did,
2016.
where's the receipts?
Don't have any, I'm sorry, Your Honor. I get so much paperwork, I don't have any receipts. I just don't. All I have is my ledger to prove what it is I paid and the difference in their ledger to show that what they did, that's not right.
Sir, I'm looking at the ledger. The balances that are in here are not because you gave them any money. It's because of overpayment. That's why I'm asking you to show me proof.
I can't, Your Honor, because all I have is ledger. That's all I have.
No, you came here and you alleged that they committed fraud and took money. You're gonna show me where you had money, because you're on Section 8. And so Section 8 is paying the majority of your rent, and at some portions of your time there, your contribution was $0, meaning Section 8 did not believe you had enough money to even make a payment. And you want me to believe that you gave them $1,400, and you better show me where the $1,400 came from, and you better show me where you gave it to them.
Okay, over 10 years, I can't. Over 10 years, I can't. I
There-
don't have it.
There was,
I don't have it.
there's no, $1,400 wasn't sitting in an account over 10 years, sir.
No, it wasn't. It was building up to that. but
That's
can't-
not true.
I
That's not true.
I can't prove anything now, so I can't. All I have is my ledger. That's all I came in with, is my ledger, because that's what I thought. That
And this
honestly
ledger
was
only goes back to 2024.
2023, November 2023, because they would not give me anything beyond
The
that.
ledger you gave me,
Yes,
there's nothing from November 2023.
yeah, there should be, except in my ledger, I could not, because I started getting my ledger from them in March of 2023, when I found out they were stealing from me.
This is
That's
from
when I started
twenty
getting my
twenty-four,
ledger.
sir. This is not from 2023.
My ledger goes back to 2023 and their ledger goes back to,
The one you
My-
gave me does not go back to
Sorry.
2023.
it
sir.
goes to March 2024. My ledger goes to March 2024. Their ledger goes to November 2023. That's what it
correct.
is.
And in
Sorry,
2023, the ledger that I have does not show that you had a balance that was accruing. It said that you had a security deposit of 515.
But my ledger does show that I did at the time. I had 17.
Where is
so
that?
100. That's my ledger. What you have.
Your ledger doesn't go back beyond
Because
2024.
they won't give me a ledger before that.
Do
They
you have a
won't
ledger
give me-
prior to 2023?
Yes, it was one of the exhibits. He was already
Which-
provided with.
Is that the one that she went off here, this one right here?
No, that was Exhibit E, Judge. The ledger from 2023, we marked as our exhibit number D, or letter D.
This is just 2020. Okay, this is 2017. Let's see here. 515. Rent charge. Looks like bank transfer payments. It says the account that it came from, the amount of the payments that came from Mishta. Looks like rental charge payment came from bank transfer from Mishta. The only thing I see going into this account comes from Mishta. There is never any cash or any other deposits being paid in here. And the checks numbers are being attached here, the amount of the check and then the balance. There's nothing here that reflect that you contributed to the overage that was reflected here.
The only thing I can say, Your Honor, is I'll never do this again. I'll never expect them to hang on to my money. I will never.
Well, it's
do
not their
that
job to hang on to your
No,
money.
you're right. It's not.
However,
It's not. It's
however,
not their-
you have not even proved that there was money that you put in there.
That's all I have is my ledger. That's all I can do. That's all I
Okay.
can show you.
Okay.
No need to really go
Thank
and
you.
think because it's all I
As
can
to
do.
your, are you ready to make argument? Any further argument for you?
I can prove a lot more things they said are lies, but I don't think it's gonna much
Okay,
matter.
just because they said things that were lies, don't mean
Alright,
that you
then
get paid for it.
I'm
I'm trying to see, you filed a claim, sir, and you alleged that you were suing for $3,020 for money they stole from December 2025 and before to November 2023. You said you were suing for $2,747.70 for all the illegal and misappropriation of funds from January 2024 and beyond to March 4th, 2024. And then you allege $5,000 for intentional infliction of emotional distress and ongoing harassment, which you have failed to prove. Flat out, the $5,000 for intentional infliction of emotional distress. A lot of people like to throw that claim out there. I don't think they understand how much of a burden it is for you to prove intentional infliction of emotional distress. You don't just get to sue for IIED because you're annoyed or because you're talking over the judge when she's talking, or because you were annoyed, or because you had to deal with something that frustrated you. You really have to show that the other party did something that was so egregious and they did it with the intent to inflict severe emotional distress or to harass you, and that because of that you were inflicted with such harassment, and that's evidenced by medical records, or I had to go get counseling because of what they were doing to me, or I had to do X, Y, and Z to recover from whatever they were doing to me. Nothing that you're sharing with me based on what you're saying is anything that can go to their intent to inflict emotional distress on you. And so that claim is dismissed. Your claim for $2,747.17, all illegal and misappropriation of funds from January 2025 and beyond to March. It's unclear what happened between January 2025 and March, but based on your own testimony and your own questions of this witness, it sounds like you only made one payment between that time, and that was of $12. So I don't see how they misappropriated any funds of yours during that time. I asked multiple questions about the charges for sewer, because I do see in the lease where you weren't supposed to be charged for that, and I do see the RIFTA is what it's called. At least one RIFTA, I don't know how often you receive those, that says that you were not supposed to be charged. And then when I look through the documents that you did provide, which were from Michigan, from MISTA, about the adjustment for your housing voucher, it's, most of them say that you weren't paying, you're not paying utilities. That's what most of these say. And so I would tend to agree that you should not have been paying the utilities. Maybe MISTA should have been, but it doesn't sound like MISTA was aware that they were paying it, or maybe that was what was included in the rental increase. I'm not sure. It tells me what your portion was, but it also, but even if I believe that you were supposed to be paying it, it doesn't sound like they have sought to recoup it, that you never paid it anyways. So I can't give it back to you because you never paid it. And when you moved out, they dismissed their claim. And we're not seeking to move forward because it was just for possession of the property. Lastly, your claim for $3,020 for money that you said they stole. You've not been able to provide any proof to this court that you placed money into the account that was taken out. To the contrary, the court has looked at 4 different ledgers at this point, and these ledgers all show money that was going in and what was coming out. The only money the court sees coming in only ever came from Michigan Housing Authority. I never see anything that came from a private or from you, a payment that was made from you. And then the witness, I think, aptly explained how it was that there was an adjustment, and that's because they were on your ledger putting your rent lower than what it was supposed to be, and that it should have been $715. When I look at the notice from MISTA was advised that your rent was supposed to be $715. So when they went in and did the adjustment, it took out what the overage was, and that's because MISTA was paying what they were supposed to be paying. The landlord was not charging what they were supposed to be charging. And so for those reasons, I'm unable to grant you any relief that you're seeking. Your claim is dismissed. Any additional matters for today?
Yes, and for the record, Your Honor, every document that he provided to me, I'm giving back to him right now.
Wait a minute, because I'm gonna do the same thing. I'm gonna give you all of your records back. I think it is good that you, I think in general, you should keep all of these records. You might have been missing a couple of your MISTA forms, but you want to get a folder and keep those for your records, even in your new place, because you never know what you might deal with.
Yes,
So
and I'm a little bit more educated now on what to do next time that somebody does this.
And Judge, I'll prepare an order dismissing his claims with prejudice.
thank you. Let me give you all of these forms.
So I'm you're dismissing everything against me, I'm dismissing everything against you, correct?
That is correct. The case is a
Thank you,
wash.
ma'am.
Thank you.
Thank you, ma'am.
These are giving everybody their paperwork back.
Okay. I
That's
have no problem.
theirs, and this is
Thank you,
his.
No problem, Your Honor.
Thank you.
Thank you for all your help, Your Honor.
No
Thank you
problem.
for the education, all the
No
FYI.
problem, sir. I'm glad that you have a new place. You were able to maintain your subsidy,
Yes.
and
yes,
that's
absolutely.
what's important.
Correct. And that's the most important thing.
Exactly, and you be safe, okay?
Yep, so I'm working, I'm got a place, I no longer need to be there. I'm a happy man.
Very good. I think
Thank
everyone's
you.
happy. Thank you.
Judge,
Thank you.
we have one more issue. There is, I believe, $60 sitting in court escrow,
Oh,
was not released ever.
it's about 72
Oh,
or
is
80.
it?
maybe.
Last time I checked, it was 60, Judge. I don't know exactly what it is.
It's about 80 at this point, I think. $84 in escrow for the months that was for his $12 payments.
Correct.
That's to be released to
Yes,
the
Judge.
landlord.
Okay,
And do you want it all in the same order as the dismissal, Judge?
Yes, please.
Thank
I'm
you.
sorry, there's one more thing I have.
Yes.
Now, at the end of the video, during my walkthrough with Sharice, I think her name is, she said she was sending my security deposit 515 to my aunt. Am I still getting my security deposit back? Because I have a video of her stating that she is giving it to me.
I'm not sure. So their laws are very specific about how they address security deposits. It needs to be released back to the tenant unless they send
I have
you a itemized reason of why they're not.
nothing, but I have you, Sharice, on video stating that I
You all
was
can address that outside.
You don't have to be on video.
You don't need to do that. You don't need
Okay,
to
so
do
you're
that in my
not going
presence.
to, I gotcha,
Have a balance
you're
of
not
1
going
buck.
to, okay, then. yeah,
Did
small
did you
claims for
provide them, did you
550.
provide them with a forwarding address when you moved?
Yes, I sure
Okay.
did. I
Okay,
gave
did
you
they,
the address to give.
and did they send you a notification within 30 days of why they were withholding your rent or your?
No,
It's done electronic.
no,
Oh, they said,
nothing sent electronically
they
to
said-
me.
I'm sure would have evidence of that, hopefully. Maybe you can get a copy,
I wouldn't, how can I get it if I don't live there, Your Honor?
I mean, our office
a
is
copy
open.
of the
Of-
email.
Of what they're saying.
She said they sent, you sent it to his email?
It's done electronically, yeah, but you can always just walk into the office and we can print a copy. It's easy.
Can you mail him a copy
I've
to his
got-
forwarding address, please?
I can.
Thank you.
So the video of her saying that I passed the inspection doesn't fly?
I don't know.
got her
I
on video
don't know
stating
what your evidence is. If you believe that they violated your rights, you have the right to pursue that in small claims.
Gotcha,
Thank
okay,
Deposit was applied to your.
Thank you.
balance.
Okay.
You're all set.
thank you, Your Honor. I don't.
Please escort them out of my court.
Yes.
Judge, just for the record, defendant slash counter plaintiff, counterclaim is dismissed with prejudice. All monies that are held in 54A district courts escrow is hereby released to the plaintiff Pacific Flats and mailed to the law office of Aaron D. Cox PLLC, and I gave the address, if I may present this. And I did update his address in the case caption to 3125 Eden Road, Leslie, Michigan, 49251. That's correct.
That's the one. That's where my security deposit should be going to. Counterclaim is dismissed.
Why don't you won't let me put a note in here?
Okay, perfect. Thank you. Thank you, Your Honor. That was it for the Cox docket. Have a
So
great
they
day.
want my escrow is what they're saying in this. They want my escrow.
The escrow, I ordered the escrow to go back to them. That's who, there was.
Oh,
you
they're
were-
getting my escrow.
Yeah, when, that was to
Okay.
pay your rent.
Okay. All right, Your Honor, thank you.
Thank you, Judge.
All right.
Thank you.
Oh.
I don't know why is on base not letting me put a note in here? Did they close the file or something? Did I miss something?
Judge, and, oh, he left. I will inform